Oxford Book of Legal Anecdotes by Michael Gilbert. It's a great book we picked up from a great friend of ours from his personal library. The Oxford Book of Legal Anecdotes by Michael Gilbert, C.B. The well-known crime writer was, until his retirement, a solicitor with a Lincoln's Inn firm, a highly fictionalized account of which he gave in one of his best-known novels, Smallbone Deceased. He has been for many years a pillar of the Society of Authors and the Royal Literary Fund. So in the introduction, the editor writes, that is Gilbert, that this book is a collection of extracts from the published reminiscences of judges, barristers, solicitors, magistrates, and also of a variety of people who have viewed the operation of the law not from the eminence of the bench or counsel seats, but from the witness stand, the spectators' gallery, and even from the dock. The source of each extract is noted at the back. A limiting factor in selection has been the meaning of the word anecdote. It will be readily understood that this is not a collection of jokes, but the format does demand some observance of the dramatic unities of time, place, and theme. Each extract describes an incident in the life of the character principally concerned. It has been necessary in some cases to set the scene. The curious experience of Sir Patrick Hastings in the military court in the Ruhr would be incomplete without some account of the difficulties he experienced in getting there, as would the tribulations of poor Mr. Stokes on his visit to Brixton. On the whole, however, shortness is the essence of an anecdote. So he writes, I have used a minimal amount of editing. The notes of the head of an anecdote are mainly designed to identify the speaker where the text does not make this clear. I noted that the American editor of a similar compilation wrote, in quoting as I do throughout, I have frequently used ellipses, brackets, paraphrases, and other sly means to avoid repetition and technicality and to achieve brevity. I have not followed this the whole way. I have added nothing of my own without making it clear by the use of italics in headnotes or square brackets within an extract. And I am commenting rather than quoting. On the other hand, I have not hesitated to leave out words, sentences, or even complete paragraphs if they seemed to encumber rather than assist the point of the story. Also, in the shorter passages, when it may not be clear who is being talked about, I have sometimes substituted actual names for expressions such as the plaintiff, the defendant, or the accused. So he also writes that it will be seen that the anecdotes are not confined to Great Britain, but also across the Atlantic, that is America. And he writes to the correspondent of the Oxford University Press in Australia. So even Australia. So he's talked about that. The field was rich enough. Whether it has been reaped to good effect, the reader must judge. No doubt some will be grieved to find a favorite story omitted. I can only hope they will discover others which have previously escaped them. I have myself been a devourer of legal biography since being introduced at an early age to Marjoribanks' classics, Life of Edward Marshall Hall. Since I undertook the present collection some 6 years ago, I have sustained an almost undiluted diet of such works, he writes. So So he also writes that there are few lawyers in every age who catch the eye to such an extent that they become public property. The growth of the popular press in the second half of the 19th century brought the names and the fame of F.E. Smith, Marshall Hall, Rufus, Edward Carson to the sort of public attention that is currently accorded to Lord Denning. It was the same forces that promoted Clarence Darrow, Sam Leibowitz, and Earl Rogers in America. So he writes that I came to realize, however, that there was a different sort of fame. There were lawyers as opposed to public lawyers. The line of distinction was not always clear. Many people outside the law recognized the name of Rigby Swift and Curtis Bennett, but for Charlie Bowen and Theo Matthew and Peter Edlin and William Moll, the bells of memory rang fainter and fainter. Yet these were men who delighted or infuriated a whole generation at the bar. A second and a rather sad discovery was that it was not by no means the most eminent who were the most quotable. There were exceptions, of course. Lord Russell of Killowen breaks all the rules, as he did throughout his tempestuous career. Others were less fortunate. They had biographers who were overconscious of the gravitas and position of their subjects, sometimes plowing through them with a despairing hope that there must surely have been occasions when the author took his subject a little less seriously. I found my eye drifting to the bottom of the page. There, tucked away in smaller type, a glint of humanity could sometimes be found. It was as though the biographer, faced with some flippant triviality which he hesitated to insert in the text, thought he might slip it inconspicuously into a footnote, an oasis in the desert. There was another side to the coin. No man, as they used to say when such functionaries existed, can be a hero to his own valet. Barristers and judges have clerks. The relationship between them would merit a full-length study. The clerk may be anything from office boy and typist, friend and adviser, to landlord and virtually employer of the barristers in his charge. And when a barrister was elevated to the High Court bench, his clerk might go with him, often to the detriment of his own pocket. The books of Arthur Smith and A.E. Bowker, Sidney Eyelet, and F.W. Ashley provided very welcome relief. These were men who saw the judges and barristers without their wigs. Their affection for their masters was clear, but it was far from being reverential. When considering these men, eminent and in some cases truly formidable, there is another comforting reflection. Lawyers, as Charles Lamb reminds us, were children once, and not only were they children, they all had to start somewhere. When I read the biography of a well-known man, says A.A. Milne, I find that it is the first half of that holds my attention. I watch with fascinated surprise the baby, finger in mouth, grow into the politician, tongue in cheek. The moment of truth for lawyers comes when they first rise to their feet to address the court. First time up, within inverted commas, is a moment which the most self-possessed of them never seem to forget. Geoffrey Dowling Roberts, a tough extrovert who in his youth played rugby football for England, writes, "The importance of the occasion the presence of my father seated beside the deputy recorder, of my mother, sister, and hosts of friends in the gallery, having come to hear Geoffrey doing his first case, all conspired to bring on an attack of nerves which deprived me of the power of speech. I was completely tongue-tied and could only produce animal noises, making not a grain of sense. His shame and mortification, as he says, could be better imagined than described, but he derived some comfort when he read in the autobiography of Sir Patrick Hastings, another robust character who had survived 2 years as a trooper in the South African War. The description of his first appearance in court: "My mouth was strangely dry. Even my opening words, which I had learnt by heart, had left me. I wanted to get out, to run away, but my legs refused to act." So, procedure in the English court of law, unlike the continental, is based on the adversary system. The theory is that in the heat of the battle, the truth will be forged. It is in such contests the character of the lawyer appears, honest or devious, forthcoming or cold-hearted, likable or detestable. And it is a record of such contests which seem to me to be the legal anecdotes most worthy of preservation. So that's what he writes. So then he says, he gives a lot of examples, and another writes, "Another occasion on which the character of the lawyer and of his victim, the witness, becomes sometimes painfully apparent is in the course of the bout of legal fisticuffs, which is known as cross-examination. Some of the questions and answers have become enshrined in the mythology of the law. Carson asking Oscar Wilde, 'Did you kiss him?' Burkitt's in the burning car case requesting the unhappy metallurgical expert to oblige them with a coefficient of expansion of brass. Then, let's just come to this. Max Beerbohm expresses the true addiction. The greatest of all delights that a law court can give us is a witness who's quick-witted, resourceful, thoroughly master of himself and his story, pitted against a counsel as well endowed as himself. I doubt whether I shall have a day of such acute mental enjoyment as the day of that cross-examination. 2 points stand out. It was not an hour, not even a few hours. It was a day of cross-examination. It is only in the works of fiction that counsel demolishes a witness with half a dozen well-chosen questions. The process in its highest examples can be as lengthy and as complex as a great musical composition with its introductory passages. Now I don't know the pronunciation, it's largo, it's accelerando and marcato, and it's artfully devised complex. The arrangements of the extracts was cause for some thought. Normally, with poets and prose writers, it would have been chronological. Such an arrangement has the merit of allowing the reader to observe changes in style and see how the Elizabethan school develops into the classical, the romantic into the modern. There are, however, no schools of legal behavior and utterance. The comments of Mr. Justice Maud, who was born in 1788, on the unfortunate result of hearing too many sermons, on the use of 4- and 6-letter words, or on the defense of consent in case of rape, seem totally contemporary in style and spirit. An alternative might have been to collect into sections All the stories dealing with certain recurrent topics: obstinate juries, unsatisfactory witnesses, overbearing judges, but this carried corresponding disadvantages. A single dish may be palatable, no one wants a dinner of it. A distracted judge once said to a barrister who was rambling in his discourse, "Could we not have some arrangement of your facts, Mr. X? Logical, chronological, or even alphabetical." The advice was intended satirically, but it seemed to present a possible solution. An alphabetical arrangement would produce an agreeable melange and have the additional advantage of enabling a reader to locate his favorite lawyer more easily. So, in each case, the extract has been headed by the subject of the episode, where the subjects are on record in the Dictionary of National Biography, Who's or similar standard works of reference in their country. The dates of their birth and death, or birth if still alive, appear against the name in question. Most of the remaining subjects can be traced through the law list. So, he says, law list reveals no record of a solicitor of this name in the decade in question or in the surrounding decades. Possibly the book was written under pseudonym. Okay, so I'm not going to write. He's talking about one curious exception, etc. So just let's go ahead. George A. MacDonald, a solicitor and a rhymester, speaks bitterly of a judge laying law down with impatient force, jesting no matter how ill-timed, of course. And Evelyn Waugh, writing to his friend Nancy Mitford about the witticism of Mr. Justice Table, says, the jury were not at all amused by the judge. All the 300-pound-a-day barristers rocked with laughter at his sallies. They glowered. This was not what they paid a judge for, they thought. Nor must it be supposed that this attitude is confined to the sardonic and serious-minded. Theobald Matthew was a lawyer who delighted all who knew him. He was, said Patrick Hastings, a man with a mind that saw humor in everything, and his clerk Sidney Allen described him as a sunny wit with a unique and delightful sense of the ridiculous. But this was out of court. In court, adds Allett, he never attempted humor. Judicial joking and jesting was a habit he abhorred. Is the truth of the matter, then, that whilst anyone else may, in suitable circumstances, make a joke, the one person who must never do so is the judge? It is a not unreasonable interdiction. The judge is in a privileged position. He has an audience as pre-sold as a headmaster with schoolboys, or the colonel in the mess with a respectable group of junior officers, a privileged position which should not be abused by the purchase of cheap laughter. Quite small jokes go well in solemn surroundings, says Balfour Brown, and that is why there is more laughter in court over a crippled witticism than would welcome it elsewhere. It was failure to appreciate this that destroyed the reputation, otherwise a deservedly high one, of Mr. Justice Tarling. Counsel are in a somewhat different position. If a joke will deflate a hostile witness or will advance the cause of their client by winning the smiles of the jury, then they are fully entitled to make it. Even then, a seemly moderation should be the rule. Witnesses, who are the only other people who speak much in court, are not encouraged to joke. If they try, they will be sat on at once. Pray remember, sir, that this is no matter for levity. Serious issues are at stake. They can score points, but very rarely. Few witnesses have the wit of Whistler. Perhaps the most balanced judgment on this question was given by Judge Edward Parry in the 7 Lamps of Advocacy, and the last word shall be with him. Nor can laughter in court, a derogatory parenthesis unknown in the official law reports, be wholly condemned. Laughter may be derisive, unkind, even cruel, or it may be used as a just weapon of ridicule, wherewith to smite pretension and humbug. It may be gracious and full of kindliness, putting a timid man at ease, or instinct with good humor, softening wrath, or mitigating tedious irrelevancy. So that finishes the introduction, where Michael Gilbert then has thanked so many people out there. You can read it for yourself. So here, this is a note on nomenclature and functions, and most of the people quoted and described here started as barristers, he writes. And then he goes on to talk about others, and then what sort of caught my eye is there are some particular points on function which might puzzle readers who are not familiar with the British system. The first is the difference between solicitors and barristers. Shortly, the solicitor is the man of business to whom a client first comes. He can deal with most difficulties himself, but if his client is destined to end in front of the High Court, a barrister will have to be briefed, since he alone has a right of audience in this and in higher tribunals. So he's written, he also writes, the introduction mentions that procedure in the English court is based on the adversary system. It is gladiatorial. The barrister on one side, or in a lower court the solicitor, fights for his client against the equally professional champion on the other side. The judge acts as a referee. This is in contrast to most European systems, in which it is the judge who has the conduct of the matter. He questions the witnesses, examines the prisoner, listens to any legal submissions that counsel may wish to make, and arrives at a conclusion. A curious offshoot of the British system is that barristers are free to appear on either side. They are not, as for example in Italy, trained to operate throughout their careers as prosecutor or defender. This freedom extends even to those who have taken office. There are a number of earlier occasions when an attorney general put out of office by a change of government is found defending prisoners whom, when in office, it was his duty to prosecute. So, etc. Very interesting. The book is really interesting. You must read the anecdotes. They are very good. I'm just going to open a random page and read. Okay, it has just opened to page 260. So this is Jeremiah Mason, 1768 to 1848, American senator and lawyer. An interesting account is given in the green bag of one of Jeremiah Mason's cross-examinations. The witness had testified to having heard Mason's client make a certain statement, and it was upon the evidence of that statement that the adversary's case was based. Mason led the witness round to his statement, and again it was repeated. verbatim. Then, without warning, he walked to the stand and, pointing straight at the witness, said in his high, impassioned voice, "Let's see that paper you've got in your waistcoat pocket." Taken completely by surprise, the witness mechanically drew a paper from the pocket indicated and handed it to Mason. The lawyer slowly read the exact words of the witness in regard to the statement. They were in the handwriting of the lawyer on the other side. "Mr. Mason, how under the sun did you know that paper was there?" asked a brother lawyer. "Well," replied Mason, "I thought he gave that part of his testimony just as if he had learnt it, and I noticed every time he repeated it, he put his hand to his waistcoat pocket and let it fall again when he got through." So that is one. And then there's another one which, let's just read the other one. Sir James Charles Matthew, 1830 to 1908. So this is the 256th anecdote. J.C. Matthew was walking in Hyde Park one day when a man tried the painted bird fraud on him, in which the homely sparrow, by a little skillful manipulation, assumes the beauties of a tropical bird. Approaching Matthew, the man, assuming an air of curiosity, said, "I beg your pardon, sir, but I have just found this bird. Can you tell me what kind of bird it is?" Matthew, eyeing this man without any change of countenance, replied, "If there is any truth in the old adage that birds of a feather flock together, I should say it was a jailbird." So these are the little wit and humor of these people who spend their whole life with tinkering with law, bringing justice, looking at people all around. So that's the ISBN number 0-19-282-112-1. So these are the legal anecdotes, the 350 anecdotes in this book, drawn from reminiscences of lawyers and judges, criminals and witnesses, record some of the triumphs of the legal profession as well as its occasional quirks and follies. Among the many pleasures which the anthology offers are accounts of celebrated legal battles and artful cross-examinations and tales of obstinate juries, uncooperative witnesses and overbearing judges. So what I really like is there is no greater drama than the daily performed in the law courts. It has a suspense, cathartic, tragedy, rich comedy, and there is the farce of litigants, lawyers, and judges chasing each other through a series of connecting rooms, trying to avoid the banana skins liberally placed under them. As said by David Panic, a listener. Truly a book to be read. And there are short anecdotes. You needn't read. You just open the book to any page and read something, and you will enjoy it. The wit, the humor, etc.